Welcome back, everybody. Please join us in welcoming Chief Lee Seal from Sacramento County.
Thank you and good morning. We've heard this morning about our commitment to research-based approaches to public safety, how this has helped improve outcomes, it's changed the work that our officers do, and how it's helped California's criminal justice system evolve. But one thing has not changed. We've always had a very close affiliation with the courts. Probation and the courts, it's always been a very special bond. We take seriously our duty to objectively assess the facts and law for every individual coming before the court, but our relationship with the court goes beyond that duty. The courts have been a partner in our journey that we discussed today. They've been committed to seeing greater accountability among the persons brought before them. They've been committed to seeing sounder approaches to rehabilitation, more effective intervention and prevention of victimization. They've supported us, they've pushed us, and we're all better for it. We're extremely grateful to be joined this morning by the Supreme Court Justice of the California Supreme Court, Justice Tani Cantil-Sakauye. She was sworn into office on January 3rd, 2011 by then Governor Arnold Schwarzenegger. And she brings more than 20 years of experience at both the trial level and appellate level. Chief Justice Cantil-Sakauye has presided over the state's highest court, and in her role as chair of the California Judicial Council, she's led her own branch through improvements in the administration of justice, creating a fairer and more just system for all Californians. We're extremely proud to claim her here in Sacramento County as one of our own, as we appreciate the impact that she's had through all of California. So please join me in welcoming Chief Justice Tani Cantil-Sakauye. Thank you.
Thank you for inviting me to say a few words. I'm here with Martin Hoshino, our Administrative Director of the courts, who, as you know, came from the experience of our CDCR. And he is here with me, and together we extend our gratitude for the bond that we have had with probation over the years. And while it is true, as Lee has said, that I've been on the bench for over 29 years, I started out as a prosecutor back in 1984, 36 years ago. And in those days, I remember probation still being an essential part of the work we did in the criminal justice system. Those were the days when, as a prosecutor, I relied heavily on the probation violation reports and the probation status reports, particularly when it came to new offenses and progress reports. Later on, when I became a trial court judge, where I was for 14 years, I remember very well meeting with probation every morning, Monday through Friday, in my chambers with 4 or 5 probation officers, having direct face-to-face contact about the people in their caseload and where we were serving them best and where we needed to do more work. Just by a show of hands out here, how many people either did that or remember those days when we had face-to-face conversations daily in the trial courts? So I see a lot of hands. And now we know, after case law and work thereafter, that we have really come a long way. When I was a trial judge, though, on the bench, I remember the invaluable work of probation, in that there were times when people were in front of me and I needed to know desperately what their status was on probation because either of a new offense or a probation violation. I remember the old days of 30, 60, 90, 120, 180, oops, off to prison, just so you can be on the parole. We can't deal with you anymore. You're going to get time served. You're going to go, walk in, turn around, come out. How many people remember that? At At the time, that was the norm, it was the standard, it was the accepted practice. There was no dispute. The defense bar knew it, the prosecution bar knew it, and we tried as best we could, given the services that we had at the local level in those days before 30, 60, 90, 120, 180, to give the best kind of attention we could without a lot of resources. And then we know, fast forward to the year, well, 10 years ago, congratulations on work well done with SB 678. I'd like to think that Senator Leno really had the vision of where California would go with this, but the success of SB 678 and the work that's being done by you to improve communities and families really lies with the practical experience that you have, that you share in order to improve services, in order to meet the goals of SB 678. As you know, and as Lee has said, we have an inseparable bond. I like to think sometimes that it's sort of like marriage vows, but the only applicable vow is for richer or poorer. That's where we are together in all of this. But 678 has really worked in California, and I cannot say this enough, because of your experience, the diversity of your experience working with people on probation, working in the different courts and communities, working with the different services, and most of all, thinking about how you can expand and make them better. This has been an innovative period for California, thanks to you. And you know that we are connected because, at least with the courts, the largest judiciary in the United States, the largest law trained in the world, we know that over 50% of felony cases are sentenced to probation. We know that this does not include, for example, split sentences or community supervision. The bond with the trial courts cannot be overstated. But at the same time, there's a bond with the Judicial Council. That is the rulemaking and policymaking body of the judiciary. In that role, Judicial Council, as you know, has the duty of collecting data and reporting back to the legislature. It's an accountability responsibility. And what we know from that experience is the success of SB 678. We know that based on your good work, that we know that the adult prison population statewide has dropped by 6,000 on a daily inmate count. We also know that the statewide probation failure rate has dropped by about 3%. And of course, essential to the purpose of SB 678 and important to all of us as to the reinvestment scheme is that over 5 years, we have saved the state approximately $935 million. That to me is a cool billion, and that's over 5 years. And we've taken that reinvestment money and grown programs based on your experience, your expertise, your knowledge, your on-the-ground work with risk and need assessment. You have become the experts on what that means and how it works. No tool is perfect, but we rely on you who have experience in education in order to implement it. That's why we thank you and look forward to working with you on the 16 pretrial projects that are looking for the best ways to look at pretrial release in the safest ways in the community. You are an essential part of this huge paradigm shift in California. No pressure, but all eyes are watching nationally. We tremble too in the branch, but at the same time, we're looking for the best possible alternative to the worst option of cash bail. And we can't do that without you, and we know that. And we know that and hope that SB 678 and a 10-year retrospective will make all the difference because the future is told by the past, and you have risen to the occasion and made this work. And that's why we have faith in your work and continue to look forward to working with you. I thank you for your leadership in these areas and the opportunity to deliver a few remarks. Thank you.